It is called the MAP Act, one of the most anti-property rights laws on the books in North Carolina. But with Governor Roy Cooper's signature on a recently passed bill, the MAP Act would be gone. It's a move long endorsed by our next guest, Jon Guze, who is Director of Legal Studies for the Locke Foundation. Jon, welcome back to the show.
Thanks, Donna. Glad to be here.
This law, the MAP Act, has been on the books in North Carolina for 30 years or so. What is it, and why are you and others so upset about it?
Well, the MAP Act empowered the Department of Transportation and other agencies and organizations as well, but primarily the Department of Transportation to impose permanent moratorium on development within designated transportation corridors. The idea was that since they knew they were going to build a road there eventually, it would be a bad thing for any new development to take place. The problem is these things sat on the books for years, sometimes for decades. The owners weren't allowed to develop the land in any way, sometimes not even doing so much as build a carport. And it went on year after year without any compensation.
Let me make sure I understand. So if the state of North Carolina determined that they wanted to build a road, say, in an area where I owned a house, they could say you can't do anything to the house, including sell it, knowing that you could end up being in a situation where they were going to take your property?
No, you could sell it, but it'd be jolly hard to sell it.
Who would want to buy it?
Because you can't do anything with it.
So you have been writing about this for a number of years, about instances where people in different areas of the state have been ensnared by the MAP Act, and some of those people ended up suing.
They did. There was a group of landowners in Forsyth County that owned property in a series of corridors around Winston-Salem, and they got together and they sued the Department of Transportation demanding compensation. They said that imposing a permanent moratorium on development was equivalent to a taking under the law of the land clause of the North Carolina Constitution, and they should be compensated.
What happened?
Well, it went up through the courts. It took a long time, but eventually it made it all the way to the North Carolina Supreme Court. The Supreme Court said, yes, indeed, this is a taking. You have to compensate these people. That's what they said to the Department of Transportation.
Tell us a little bit more about the Supreme Court's reasoning on that, because I'm sure they took into account that the state and the Department of Transportation would need to build certain infrastructure, and there would be a way to go about that. So what did the Supreme Court, how did it kind of look at the rights of property owners versus the state?
Well, there is no question that the state has the power of eminent domain. They could take land if they need it for a road, but under our Constitution, they have to compensate the owners. The Supreme Court said, and they were following the same line of reasoning that the Court of Appeals had used before, this is being done because they want to reduce what they ultimately have to pay for the land. They want to prevent development because development adds to the value. This is a way to get the land on the cheap. That's not acceptable. These people, if you're going to take away the right to develop land, you're taking away a valuable portion of their property rights. You have to compensate them.
Now, with this Supreme Court ruling, I would suspect the folks in Forsyth County and other people in different parts of the states who also found themselves in limbo because of the MAP Act would have been cheering, saying, yay, we won. Did it turn out that way?
Well, yes and no. I mean, they are winning. They did win, and they are winning, but the Department of Transportation did drag its heels for a long time about paying the actual compensation. There were many subsequent lawsuits over the value of the property and so on and so forth. But payments are going out, and slowly but surely, those landowners are getting compensated.
Now that we had the Supreme Court ruling, then why did the General Assembly get involved, and why are we now here today talking about a bill that would essentially remove the MAP Act from law with Governor Roy Cooper's signature?
Well, in effect, the Supreme Court's decision made the MAP Act a dead letter. They weren't going to be able to, if they were going to use that MAP Act to impose transportation corridors in the future, they were going to have to compensate the owners, and so they weren't probably likely to do that. Nevertheless, the legislature acted immediately to impose a moratorium on new corridors right after that Supreme Court decision, and they asked the Department of Transportation to do a study and come back with recommendations on what an alternative way of planning for future transportation needs might be. They waited and waited, but that moratorium would have ended this summer, so they decided a time had come, and they just simply repealed the MAP Act. The Department of Transportation did eventually provide a report. It was a few months late, but they did it. And so the next step in this process will be for the legislature to look at that report, digest it, decide what, if anything, they want to put in place as an alternative.
John, with a state Supreme Court ruling essentially saying that this is unfair, how the MAP Act has been imposed in North Carolina, could the legislature have simply just let the law stay enacted? Would there have been a way for the Department of Transportation to go ahead and impose it, or would that Supreme Court ruling prevail? I guess what I'm getting at is it necessary to actually repeal it?
No, it's not necessary. There are plenty of statutes still on the books that aren't enforceable, but it's better government to get rid of it, and especially because we need a way to plan for the future as far as our transportation needs are concerned. If the MAP Act is going to be unusable because of the cost, or the result of the MAP Act decision was that simply designating land as transportation corridors wasn't going to be a way to get that land eventually cheaply. So if they want to have some way to control how land gets developed going forward, they need to come up with a better system.
Yeah, and speaking of a better system, let's talk a bit about that, because certainly roads have to be built. Bridges have to be built. The Department of Transportation is in charge of implementing that kind of infrastructure activity in the state. So what are your thoughts on what would be the best approach so that property rights are rightly protected, but yet infrastructure has to be built?
Well, there's probably not any perfect solution, because as soon as the state makes it known that they have plans to use some property in the future, that in and of itself is going to have a negative impact on the value of the land. That's just probably the price we pay for living in a state that's growing with changing transportation needs. I actually like the approach that the Department of Transportation came back with in their report. They said, look, the best way for us to deal with these future transportation needs is to acquire the land as soon as we know we need it. But they also said to the state legislature, you're going to have to give us the money to do it, because obviously under state law and the state constitution, we'll have to compensate the owners.
Yeah, and so if you are an owner who finds yourself in that position, I guess you could say the earlier you know, the better, because then you're going to have to quickly determine what your options are. And now compensation, and fast compensation, is a requirement.
Yes, well, compensation is certainly going to be a requirement. How fast it will be will depend on how willing the Department of Transportation is to come to terms with landowners. This can be a long process simply if it gets into the courts. But yes, that's the way it has to be done. And at least that's the way I hope it will be done.
John, people might be listening to us and thinking this is unthinkable, that government would come in and essentially depress the value of your land, limit your ability to make upgrades, etc., and decrease the market value. They just might be surprised that this has indeed been happening.
Well, they may be surprised, but if they're surprised, it's because they don't really know what goes on. It's been happening in this state. It's been happening in other parts of the country. And it's not just when it comes to transportation planning. We could get into some other topics like eminent domain. People have to be vigilant, because property rights are always at risk.